Is Alan out?
He's not.
Hi, welcome to the House Healthcare Committee for the week. It is Tuesday, April 25th. Yep, we have a couple people out, a couple people on screen. And today we're going to have a committee discussion on two bills. The first will be S47, and the second will be S65. And we've heard testimony on and off on these two bills. The S65 testimony I wasn't really here for, so I'm going to rely on Alyssa a little bit. Tupper won't be here this afternoon. But I want to get us to a point where we can have a discussion, see what we're all thinking on both of these, where we want to go with them, if we need more testimony, and basically how to move forward on them. So Leslie, raise your hand if you have any comments. I'll make sure, since we don't have anyone else on the screen, I can see you, which is great. So S47, everyone remembers, this came to us, and it is about the process when transporting someone who's been taken into temporary custody. This is in the realm of mental health, not police custody. And so we had Dylan Burns from Vermont Care Partners come talk to us about the bill. And then we had Jack McCullough and Wilda White and Maureen Fox come in and talk to us about the bill. And as I remember it, and please hop in here, this is definitely a committee discussion. There were, other than the general policy that we have outlined in front of us, there were a couple concerns from people. So one was the constitutionality. That's in judiciary. They started taking testimony on Friday, and I'll have a conversation with Martin later today. And then, but he has indicated that, at least at first blush, they do think it is constitutional. So we should keep moving forward with our testimony. Then the second issue, if I remember correctly, was this idea of person, law enforcement officer, or qualified mental health professional obtained. So the person's in temporary custody, they have applied and they've obtained the warrant. So now they're just waiting for law enforcement to take the person, and Dylan, please jump in if I'm getting this wrong, take the person to the appropriate place for care. And there's no timeline on that. So the warrant could be out there. I think we heard one example for 30 days. The person was fine, but the warrant had to be served because it was still active. And so a recommendation was 5 days. A recommendation was from VCP and DMH. Another recommendation was 72 hours. So basically, once the warrant is finalized and they're waiting for law enforcement to transport the person, they would have, current policy is all the time in the world because the warrant doesn't go away until it does, 72 hours to transport the person, or the warrant is voided, I guess. I don't know if that's the right word, or 5 days. Yeah.
Well, I'm trying to read the changes that I'm seeing in pages 1 and 2.
Right, so let's not.
Okay, that's what we're doing now. Okay,
yeah, let's
gotcha.
not look at that just yet. Unfortunately, we don't have Katie here to go through the language changes, so we will walk through it. So I'm more talking about just general policy.
Gotcha.
Figure out the wording later on this one. And we don't have to come to a decision, but that is where I thought we were on that topic. Right.
Who, you said that DMH, and I can't remember the other group advocated for 5 days.
Vermont Care Partners, but I will say I have since received an email from them, and maybe Dylan, if you wouldn't mind, I'll turn to you, has indicated they would be comfortable with 72 hours.
And then who recommended 72? Was that Mad Freedom and Jack?
It was Jack, I put this specifically, I believe, yes. So is that, yeah, and Jack shaking his head, yes.
I would lean towards 72.
So I guess the question is, since I wanted to put everything out there, but they're saying they could move to 72 hours, let's take 5 days off the table. Is everyone comfortable with the fact that the warrant should expire at some point if the person hasn't been transported for care?
Yes. Yes.
See, this is, I'm having difficulty understanding. This bill has always kind of been a mystery to me.
Okay.
It seems like in the bill, what we want to say is that when somebody has an episode, we ask for the warrant, but the asking of the warrant allows us to take him and move the individual. And so you don't need a warrant, you just need to ask for it.
No. So, and this is where I'm going to look to Dylan. So let's say there's a situation and
Yeah.
a law enforcement officer and a qualified mental health professional, really the qualified mental health professional says, yes, we need to ask for a warrant. We can take the person into temporary custody. And this is where I again get confused with maybe what's in what happens today versus what has been proposed. But basically, the person can be taken into temporary custody while they apply and obtain the warrant.
What's temporary custody mean?
That was asked for, wasn't it, by Beth William? Asked for a definition.
A temporary custody, yes.
Yep.
Yes.
Say that again?
One of the witnesses testified that she would like clarification and thought it might be helpful for us to have that as a definition.
Yeah, because I mean, does that mean I'm out on the street with this individual? Maybe he's out of his house and it does something that needs to be restrained or he needs to be brought into custody, but right there?
So let's turn, I'm going to turn to Dylan. Are you okay with what happens today? And do you mind coming up to the table? I know you're not on the agenda, so if you don't want to, that's fine.
Jack, you can help me too. So which specific part of this are you?
So today,
Yep,
when someone is in need of help
yep.
and they're taken into temporary custody, what does temporary custody mean?
I think we have consensus that temporary custody isn't defined in the statute. It's just a term that's there. And I think practically speaking, it's about detaining or ensure the person's safe from themselves or others while the warrant is being applied for.
Okay.
I mean, can they take him to a police station, you think? Well, they
So,
could.
yeah, I don't know if you remember Kristen Briggs from Claire Martin Center talked about how in some situations that is the appropriate place, or sometimes people might already be at the police barracks because there's some question about whether there's a criminal component or, and then they determine that really it's a warrant, a mental health warrant that's going to be applied for.
Yeah, okay. I mean, I guess.
Right.
And then, but the transportation we're talking about is from there to a facility.
So then once the warrant is obtained, then there's additional potential transportation depending on where they were taken the first time to a hospital, emergency room. It would normally be the place.
But if the police officer takes him off from his home, say, to the police station he works at, that transportation's not what we're talking, under temporary custody. So that's not part of this, or?
That's part of the process.
Right.
I don't think
It's not
I don't
part of the
think,
transportation we're talking about.
well, it's part of the whole language, but I don't think it's in question.
Okay, all right.
That's the piece that I think everyone seems to be comfortable with.
Okay.
Thank you.
Listen, I think I'm a little confused also. I mean, at this point, aren't we talking about the transportation? So these are people, the warrant is essentially for an involuntary admission or involuntarily coming under the custody of the commissioner of the Department of Mental Health, right? So, I mean, wouldn't they be going to, say, an inpatient facility, say Brattleboro or maybe the psychiatric hospital? What if there's not a bed in 72 hours?
So the warrant is, another word for it is emergency transport order. It's literally just about transporting the person so that they can be seen by a physician and assessed. So it's just the very first stage of the process you were talking about.
Okay.
And so that if they're not, if we get the warrant,
Okay.
and let's say for some reason, law enforcement isn't able to transfer them for 10 days for some unknown reason, if we have a 72-hour in here, we would be saying, okay, well then after 72 hour, the warrant is null and void. Like this person needs help. We need to get them to a place to be seen.
I thought the beginning of the bill, though, was that we could take the person into custody and transport them as soon as, and they could then, as judiciously, as quickly as possible, apply for the warrant.
Right,
They didn't have
so-
to even wait to apply for the warrant
Right,
to
so-
transport. Is this a different transport?
Let me start. Go ahead. Do you have a question?
No, I have a comment. You can lay it out and then I'll
Okay.
comment.
It's very.
All right, so there is a situation, someone is called to my home. And I am a danger to myself or others. And law enforcement calls someone from Howard Center to come, qualified mental health professional. And they say, yes, we feel she's a danger to herself or other. We want to take her into temporary custody. So let's say I'm in my home and law enforcement deems I'm safe there but stays, right? So that could be temporary custody. Or they could say, I'm going to take you to the police station, someplace safe, person can be safe. So the qualified mental health professional starts the warrant process. This is the temporary custody piece. Starts that process. Then they go and get the warrant, the judge signs off on the warrant, and now someone needs to transport me to where a physician can see me and assess what's going on and what's my care. That's then they transfer me, let's say they transfer me to UVMMC, I'm now under the care of a doctor. That's the process we're talking about. So the temporary, I jumped ahead. Let me start with the issues as I see them through that process. So the first issue is this whole thing constitutional? Judiciary is looking at that. Again, testimony they took Friday, first blush is they believe it is, but they're having more testimony. Second, who saw me and is determining I'm a danger to myself or others? Today, if the law enforcement officer or the qualified mental health professional doesn't actually see whatever I have done, but there's other witnesses, they can go to those witnesses, fill out a form, get their name and number, describe what the person said, and use that as part of the warrant justification. What's in question is, should it be personally observed by the qualified mental health person or the law enforcement officer? And if not, should an affidavit have to be signed and delivered for the warrant? So that's one decision point. Keep it like it is, personally observe and or affidavit. Do I have that right, Jack, from your perspective?
Mostly correct, yes.
Okay,
There are some fine points, but yeah.
okay, let's stick.
You want to hear from me mostly right now.
Okay, let's stick to high level. So that's one decision point, right? So figure that out. We have the warrant. The person is, I'm somewhere in temporary custody, but now I need to get to a doctor to be seen. There is no time limits in statute today that's being followed. So let's say for some reason, I'm sitting somewhere for 10 days and then I'm released and no one gets me there. And in 2 more weeks, there's some incident and they see I have a warrant, well, they have to take me in, but I'm perfectly fine. I'm not a danger to myself or other anymore. So the second decision point is, should we put in a time limit on that piece so that after 72 hours, if I have not been delivered to a doctor to be seen, then the warrant is null and void? Yeah.
Now, that's a point where I
Okay.
don't think you have it quite right.
Okay, great. Thank you. Please come up and
Okay, good afternoon, folks. Jack McCullough from the Mental Health Law Project at Vermont Legal Aid. Just to get to the time limit point that you're talking about, what the statute requires is that once the person is taken into custody by a law enforcement officer, typically, they may already have the warrant or they may be applying for the warrant once they pick the person up. And the warrant says, once the judge signs the warrant tells the law enforcement officer to take this person directly to a physician or to a hospital to be examined. The time limit we're talking about is not that, because it's very clear that the person has to, once they have the warrant, they're going to the ER or they're going to the hospital or something like that. And it could be anywhere in the state. We have a case right now where the client is at Porter Hospital. They don't have a psych unit at Porter Hospital, but that's where the person is. So that's the emergency department they were taken to.
Okay.
The time limit we're talking about is if in those cases where the judge signs the warrant before the police pick the person up, the question is, how long are we going to give the police to pick the person up on the basis of a warrant? Because if the person's out there and it's 3 days later, well, the facts that show that they were dangerous 3 days ago could be totally different now. And so it makes no sense to say, well, you can just keep this warrant open forever. And so I think everyone on all sides agrees that we should have a time limit.
So can you explain that again? A time limit from between temporary custody and when the person is taken to a doctor?
No, it's the time limit between, this only applies if the police have not already picked the person up.
Okay, that was where I was. Okay, thank
And
you.
so they have the facts, they go to the judge, they say, Judge, we want a warrant to pick this person up. And they explain what the facts are. The judge says, fine, I'm signing you this warrant. You can now take this warrant out and go into the person's house if they're barricaded in their house, or find them wherever they are. And this gives you the authority to pick them up and take them to the hospital.
Okay,
And the time limit we're talking about is from the time the judge signs the order, and the judge, those warrants have not only the date, but also the actual time of day. So it could be 2:37 in the morning or whatever.
okay. So from that point till they get to a doctor?
Yes.
Okay.
No, from that point until they get out there and find the person.
And find the person?
Yeah.
Okay.
Sorry, thank you. That was a big clarification.
Oh, yeah.
But if they have the person in custody and the warrant assigned, it's immediately to a doctor.
Yep.
Right away.
Yep.
So they're not having to wait.
Yeah.
Art?
Is there any consideration given to the seriousness of the charge at all in the 3 days? If a person is, I don't know, brandishing a weapon or something, does that change the 3 days? I'm just curious.
What I would say is that if the person's brandishing a weapon, they would arrest the person anyway. They would have the legal authority to arrest them for that crime.
Okay.
Yeah. But if it's, take a different example, and I'm not a screener, I don't do these things, but take a different example. The person is outside and they're just wearing their pajamas and they don't even have socks and shoes on. Well, if it's the middle of June, probably no big deal. If it's winter, then that's going to be enough. And so the screener would then evaluate all the facts of that circumstance and to think whether the person really is a danger at that time. But so our proposal is that whatever the facts are that led the judge to decide that this is justified, I'm going to issue the warrant. The warrant is only good for 3 days. And if at the end of that 3 days, if someone thinks the person is a danger, it's probably because they've done something since that time. And so then,
Which requires another warrant.
yeah, another warrant or an application for emergency exam with a physician's certificate. Yeah. And the warrant only applies when it's not possible without unreasonable delay to get a physician to examine the person. And the warrants used to be kind of an unusual way to get the people into the hospital, and now it's much more common.
Brian, did you have a question for Jack or just more of a?
I have a comment, but I do have a question based on what you said.
Sure.
What you just said. You said that if they become more common, what was the practice before?
Oh, it used to be, there are two provisions of the statute that allow the person to be picked up and taken into custody. One is called an application for emergency examination, and that's 7505. And then one is a warrant, and that's 7506. So they're right next to each other. And it used to be that the screener, the crisis clinician would go out to wherever the person is. They could be plugging people at a laundromat. They could be out in the middle of the road. And the psychiatrist would even go out there too. And they'd sign the certificate. They would meet with the person in person before they ever got to a hospital. When I started doing this in the mid-90s, that was really quite common.
Okay. Thank you, Jack. Appreciate your help on that. Thank you for clarifying.
Yeah, I appreciate that too, because I remember doing assessments in the field and what we call an EE, an emergency evaluation, starting wherever the person was at, and then coordinating with the system, how do we get them to the emergency room eventually to complete it, but that we would start it. And then I have seen a shift to now there's these warrants and the police are looking for people for a week and they can't deliver it, or they say they're unable to, they don't have enough staff to go out and find them or whatever. The reason I support the 72 hours, besides the fact that that advocates are recommending it, is that it's equivalent. My understanding, I could be wrong, so you can correct me. Jack, you can correct me if I'm wrong. That when a person is involuntarily admitted to the hospital, every 72 hours you have to do a recertification. Is that still the case?
In 72, at 72 hours, they actually, once the person is certified into the hospital, they have to be examined within 24 hours of getting to the hospital. And then that gives them 72 hours to decide to file an application for involuntary treatment or not. So, yeah.
So the 72 hours is the examination period, and then they have to file for involuntary. That's 72 hours. So I think making the warrant 72 hours makes sense, because it's saying that within those 3 days that there were concerns about someone's safety, we want to make sure we're delivering that warrant. And if we don't, and then we need to reapply based on where they're at. Just like within those 3 days, if a person doesn't meet the criteria to be held involuntarily, they can switch to voluntary, or they're free. And I just think it's important to balance the restriction of people's freedom with safety, and that this change in time, it creates a deadline that if there is continued concern that our public safety apparatus, and that's not just the police, but it's the crisis service and EMTs, everyone, that we would hopefully be able to deliver that warrant and get the person in for an examination. And then if they meet the criteria for an EE, then they will go through the next 72 hours. So I just think it's good to have that. Deadlines sometimes create pressure for people.
Right, that's what I was gonna say.
And then if we miss the deadline because the person can't be found, when they show up again, we need to reassess. And I think that's important. We would need to reassess the situation and determine, do they need a warrant? Maybe they would voluntarily accept treatment if at that point. Or maybe they are actually not a risk. They don't pose a risk to themselves or others. And under the current system, that person's freedom could be violated. They could be dragged in for an unnecessary exam. And so that's why I think maybe that's not the best way to put it, but it's if they're forcing someone to participate in any kind of health assessment against their will, to me is a big deal. And so if after 72 hours they don't meet the criteria, we shouldn't be forcing them. That's just I would just trust the advocates, but that's my rationale too. I also want to say, like, I heard, I don't know who, somebody mentioned, and maybe they didn't, like, you may not have meant it this way, but you were saying when someone has an episode, I just want to clarify that it's not just having an episode, like, of symptoms, it has to be, like, that a person's really clearly a risk to themselves or others. And that, these warrants aren't just given, we don't just issue warrants because a person's has a mental illness or is struggling. It really has to be, like, proven that they pose a risk to themselves or others,
Just use that as a,
Yeah, I just wanted to clarify. I don't think you meant it in any negative way, but I was just saying, like, that it's really important that, it's not that we don't restrict someone's rights just because they're struggling, with a mental illness, and that it has to really be a clear danger to themselves or others.
Thank you, Brian. So let's stick with the 72 hours since we, what is everyone else?
what was it? I'm sorry.
There was nothing. There was no timeline.
So a month later, someone could get picked up when they're fine.
So Daisy and then Bobby.
What is our, Ellen, you might know, what is our number, say annually, of EEs requested or people who are under involuntary status versus other states?
I don't have that data. I will say Brandy sent in some written testimony. Brandy Littlefield testified on Thursday, and she included data on that for Howard Center for Chittenden County. It has EEs, warrants, and overall assessments. It was like overall assessments was like 8,000 in a year for patients so far this year, and the number of warrants was like 229. And I think that's higher than most regions.
Because Brian's comment got me thinking about, if we did have a 72-hour warrant expiration and had to reassess an individual once they were back on someone's radar, if the individual were incredibly putting themselves or others at incredible risk. I'm just remembering some of the conversations that were had around competence and insanity and people who were justice involved and victims and potential victims and their safety and what they might say in that situation, and just thinking about, I don't know, how to balance that, I guess. And so thinking about our practices and capacity to keep them safe at the same time. Just thinking out loud. I really have a point.
That's okay. No, thinking out loud is good.
Looking at the data to see, like, how effective are we at finding other solutions versus using involuntary as a solution? Are there other pathways to helping people is what I'm looking for.
Bobby?
Well, I'm generally in support of the 72-hour, limit on the warrant, but I can imagine, and there's things that I can't foresee where there could be a need for an extension for various circumstances. And there is no limit on someone applying for another warrant, but would they have to take new affidavit? Or could they use the old ones to get a warrant like renewed? Like what if somebody is like hiking, something, and or the particular episode that they had is of a unique kind where it won't just go away after 72 hours. You know what I'm saying? I'm just wondering if there's some kind of like emergency extension provision that we could add to the 72 hours that has to be signed off by a doctor or all that without requiring the whole process to start over again. So that would give an extra tool for unique circumstances that I can't even predict.
Right.
Like they went on the long trail and, we know they have a gun. Like maybe we should extend this because this one is a particularly unique situation.
Because you can't get to them in the time frame.
Yeah, because you have to literally go hiking to go find them or something. I'm just foreseeing something that could happen.
Right.
But that way it would assuage the concern about, it's like the technicality, like, we got them at the 73rd hour, we can't do anything anymore. Our hands are tied, but this person is still in danger or a dangerous individual. I don't know. I was just proposing that there's some kind of extension that could be added. So the default is 72 hours unless you apply for special consideration. I don't know.
You can appeal it or something.
Yeah, something that would be a little quicker just to give flexibility for those kinds of unusual circumstances.
Okay, Brian?
So I'm not a QMHP, but I work with them. And if I had to answer that, even though I'm not a witness right now, it's common where like a person gets an assessment and there's recommendations made and they don't meet the criteria for involuntary and they walk out of the hospital right on the borderline and everybody's like, oh boy, like this isn't good, but we can't stop them. And then something happens 2 days later and they get picked up by the police and they come to the hospital. And when you file, you say, on this date they were assessed, on this date they were assessed, on this date they refused treatment, got picked up, so that you don't have to reinvent the wheel. And so it could be, I mean, a QMHP might need to testify to really be clear about this, but like, it could be that like the warrant expires and then family member says they were seen in town, they were doing some of the same dangerous behavior, I'm worried again. And when they go to pick them up and if they get found and they apply for that warrant, they, in the application, they would just take everything from the previous warrant and then add in, they ran away for 5 days and were found and detained and they're still exhibiting these symptoms. So I don't think it would be a lot, like I don't know if you need, I think applying for an extension might be as complicated as just applying for the warrant, and using, so I don't know if we would need that, but it might be good just to get a witness in who's you know what I mean? Just to clarify that, is it gonna be harder or easier or equal to have an extension or just apply for the warrant, based on the previous findings? And the main thing is presenting info. Like a person can have a history, but it's all about like where they're at in the moment. And if a person has a history and then of refusing treatment and being dangerous, and then in the moment then they disappeared and they come back and they're still being dangerous, I think it just reinforces the case for going down that path with them. And ultimately, we always hope someone becomes voluntary. I mean, that's my hope. It's always that someone says, you know what, I'm going to get some help right now. I see that, people are worried about me. Anyway.
Okay. Melissa?
I'm just trying to, because that was my concern, what Bobby was talking about. But theoretically, because we're only talking about people who 72 hours, but these people were not in temporary custody. So at hour 73, they find them. Theoretically, couldn't they at that point then put them into temporary custody and go through the warrant process again? And this time they wouldn't be out on the long trail or wherever. I mean,
The way this is written, yeah.
so that's how it, so even if it is extended past that 72 hours and you have to refile, you then could hold that person temporarily so that you wouldn't have to go through that again. Right? Am I right?
I think only if, I'm gonna look to Jack or Dylan, I think only if there is a new situation that has been observed. Because if the 72 hours is up, then technically that thing that happened that led to the warrant is done.
The person has to be a danger
Yeah.
at that moment, whatever it is.
But they could still be.
Yeah, which is still could be, they could be still threatening suicide or whatever, yeah.
So kind of, yes, right? So 73rd hour, the person seems fine, so you're done. Or there's still a threat to themselves or others, and then you go through that process again of getting the warrant, which would kind of be like the extension. But I'm still writing down what you said, Art, and then Daisy.
Who recommended 5 days, Lori?
Jack.
Okay.
No, sorry.
Yeah.
I did that wrong, completely wrong.
Further
I just happened to be looking at Jack.
in further understanding this, I'm not so sure that makes more sense. I don't know. I know so little about this field, but, I hate to see us cover up our noses right our face in terms of the effort it takes to do what we need to do, or what's good for the person. So anyway, just.
Yeah, and I can understand that. I will say, I think that if both sides are coming together to say 72 hours is okay,
Yeah.
I'd be more apt to go with them if they were still far apart.
Yeah.
But I think if everyone seems to be the advocates, DMH and Vermont Care Partners. Easy?
I'm wondering if it's just me or I'm struggling because at the end, line 17 on page 1, references application to a Superior George for a warrant for an EE.
So can you say what EE is? You keep.
Emergency examination, line 17.
Yeah.
Emergency examination. And line 21 also references applying to the court for a warrant. And so, and reading this, I feel like, I know you don't want to get into revising the language of the bill, but I'm finding, I'm struggling to really fully understand the process and intent of the conversation because of the language of this.
So I think the 72 hours is a policy decision on that specific issue, right? The person isn't in temporary custody. I get where you're coming from, but I also don't want to revise the language without Katie here. We will have Katie tomorrow. So we're not making decisions today. I just want to see where we all are and how we're going forward. The language that she put in here, I would really like to have her walk through it with us.
Can we, maybe Dylan can help us around the warrant, or I'll just try to explain what I understand it. The request for a warrant comes first, or the emergency examination comes first?
The warrant comes first.
Okay, because in this, the emergency examination does, which is why I'm confused, and then the warrant would come second. So the warrant comes first if the person is not in custody, right? That's the thing.
So I think you need to look at A and B separately too. So A says you're applying for a warrant to get an emergency examination.
Okay. Warrant for an emergency examination. And then the other one is a warrant.
It's the same process, but it's the same warrant, but it's talking about when the person is in temporary custody, getting to, and what that process is to get, what can happen while they're in temporary custody, when they have to try to obtain the warrant, and then by the time they have to have it done. But it's all about the same warrant process.
And that's a warrant for an emergency examination?
It's the same warrant, yes.
Okay. Because I thought earlier we were talking about a mental health warrant or something when the clinician from Howard Center was in.
She might have called it something different.
Same
but it's
thing.
the same warrant, yeah.
And then physician certificate on line 16.
So again, we need, or maybe Dylan can answer that. It's current statute today, but
A law enforcement officer or mental health professional may make an application not accompanied by a physician certificate to any superior judge.
That's all existing language.
I want,
That's only because it's not available.
Dylan.
Yeah. So Burns from my care partners, Jack, correct me if I'm wrong, but I think that's, a situation where the psychiatrist used to come out in the field and be able to do kind of that first assessment. In this situation, there's the warrant, but there isn't a physician's certificate. Is that correct?
Okay.
Getting the application for the warrant and then getting a judge to sign the warrant is essentially a substitute for getting a physician certificate before the person's taken into custody.
So that would be like a field eval, the physician certificate?
Yeah,
Okay.
and those don't really happen anymore.
Thank you.
Art and then Marty.
Are we the committee of jurisdiction?
We are, yes.
We are the committee, so this is gonna be our vote to take.
Yes.
Yeah, just for one person, I support this based on what I
Great.
hear and see, but I just having a hard time understanding it.
So we're gonna, when Katie comes, and this is part of what happens at the end of the session, legislative council's in a million different directions. And so when we have Katie later this week, she's gonna walk us through some more of the process outside of the language. We were supposed to have that Friday and then I was sick and went home, so I apologize for that. But we'll have that tomorrow
Yeah, it seems
or the next day.
relatively simple, but it isn't simple at all.
Yes, it's healthcare.
Just can't get my brain to think in terms of this for some.
Right. Well, when you haven't, sorry, Leslie, we'll get you in a minute. I didn't see your hand. When we I think it's hard for us to grasp a situation that we haven't been in, right? Or we haven't seen.
This is true too.
So,
Yeah.
Mari and then Leslie?
So this is for clarification. So on page 1 and 2, we're talking about the same warrant process, but 2 situations where a warrant is needed. One is for the emergency examination, and that's the current process that we have in statute. And then we're talking about a warrant while they're in temporary custody. Are both of those warrant situations, are we addressing both of those with the 72 hours or just one of them, the transport one?
So remember, the 72 hours is just when they have the warrant, but they don't have the person in temporary custody. So it applies for the warrant process. They don't have me in custody. Now they have a warrant to get me. And so they have 72 hours to come take me.
So it would
to-
apply to the emergency examination because
It's all the same.
they might not have
Already have.
the person for the EE.
Right. And can we use emergency? I just want to make sure we're not using acronyms as we keep talking about this. So emergency examination. Leslie?
Thanks. Sorry to trying to unmute. I think what might be helpful for me is to kind of see a flow sheet because I'm having a little hard time figuring out what's the beginning of the process, what's the middle of the process, what's the end of the process. And Lori, you're talking about, questions that need answering and I'm just feeling confused about the flow of the processes. I may be the only one, but it would help me. And maybe the advocates could help, and I hopefully will be there tomorrow.
Yes, so Katie will be going over the flow of the process.
Yeah, there's some kind of typical flow sheets that that are sort of typical of, that we could start with where it's the system, where the process starts, where it ends, and what happens in between. That would be very helpful to me. And if you think Katie's gonna do that tomorrow, that's perfect.
I think you can actually probably already find it because it was supposed to be testimony we were going to have on Friday. I'm not walking through it though, because it's Katie's testimony.
Yeah, no, I looked at both. I looked at all the testimony that we had so far. And it's still confusing to me about when the person's in temporary custody, if they happen to be at the police, at the barracks, or they're on the long trail. And I'm confused about where the person's located and when that process starts in each kind of place.
Okay, so we will absolutely be walking through that with Katie. It's gonna be our default location. Everyone just go on the long trail.
I have a new issue.
Okay, so wait, just hold on. So the 72 hours, that is a policy issue we will have to make. So I'm gonna close that out. And let's go to Daisy's issue.
Okay. On page 1, line 13, I'll read it from the top, starting at A. In emergency circumstances where certification by a licensed physician is not available without serious and unreasonable delay, and when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment. I feel like we're giving broad license for any individual to determine that another individual is
You have to
in need of
keep reading. You have to
treatment.
keep reading. And.
And the person presents an immediate risk of serious injury to themselves.
Right.
Okay,
Or others, that's,
but before the comma and, you are still saying that observation of the conduct of a person constitutes reasonable grounds to believe that the person is in need of treatment. I think there is an issue saying that any individual can observe conduct of someone and believe that they're in need of treatment.
so now you're on to our second topic of conversation, which is the affidavit versus personal observation. So if you remember, right now, the qualified mental health professional and or the law enforcement officer doesn't need to personally observe it.
That's right now.
Well, it says it's that way that it's not what's happening in practice. Go ahead, Jack.
Right, Jack McCullough again. The issue is the statute does say the warrant has to be based on personal observation.
And we've always thought that that meant that the person applying for the warrant has to be the person who actually observed what happened. And what we've learned is that sometimes those applications are based on hearsay or based on, my mother calls and says, I saw Jack do such and such. And that's why, and I think he's dangerous because of that. And if you figure out how my mother can call you, well, good luck to you. But so the next thing that the chair mentioned was we have an issue with having these warrants be issued on the basis of hearsay. And so we have a proposal that says that there has to be a written statement by the person who observed the behavior.
Well, more than a written statement, it has to be signed affidavit,
It
let's
has to be
say.
under
Penalty and perjury.
So it doesn't have, might not be an affidavit, but it would be under penalties of perjury, yes.
So back to the question at hand. So we've heard from Jack that his proposal, but then we heard from the qualified mental health professional, Brandy, and I think some others might have gotten emails from people about what happens in the field and the process they go through if they did not personally observe the situation. And that they, get the facts from the person who observed it, they get their name and number, it's all part of the warrant process. And so this needs to be a policy decision of ours of what we do with that. And again, I just forwarded you Brandy's testimony, written testimony. You can review it. It was from last week. Claire, I'll have you post it. But anyway, that's what's in front of us. So that, I think, Daisy, this is what you're.
No, it's not. What I'm saying is that someone who hasn't been trained in mental health practices doesn't know whether someone needs treatment or not.
Well, I think that's your argument then for saying you want the mental health person or the law enforcement officer to be the one.
No, because someone could still sign an affidavit saying that they witnessed that a person presents an immediate risk of serious injury, right?
Right.
You can still witness that without determining that they are in need of treatment.
Oh, I get it. Okay. Sorry.
It's someone like me who has no training and
Right.
actually needs medical treatment, I would have a hard time saying that I could do that. But I could definitely say if I witness someone being at risk to the house or
Exactly. Okay. You don't have authority to say I need treatment.
Can you flag that for me, Katie, and so she can explain the language? Karen?
Hi, good afternoon, thank you. Apologies, so I just wanted to clarify, a person in need of.
Sorry, Karen, first, can you introduce
yeah.
yourself? Thanks.
For the record, Karen Barber, General Counsel for the Department of Mental Health. Just to clarify, because it sounds like there's some confusion, a person in need of treatment is a statutorily defined term. It's in 7101, 18 BSA 7101. So it actually has a meaning and it is defined. And it's kind of the foundation of everything, that there has to be a person in need of treatment. QMHPs, or qualified mental health professionals, get training from the Department of Mental Health on that statutory provision. Does that help clarify some of your answers or some of your questions?
Yeah, it sounds like the individual would have to be a QMHP then.
We prefer that. They don't have to be. QMHPs do get training by the department. Statute doesn't require them to be a QMHP, but regardless of whether they're a QMHP or not, they have to meet the statutory definition of a person in need of treatment. That's a defined term. It's not just like anyone gets to decide that someone needs treatment. They have to meet the statutory definition of someone who needs treatment.
Thank you so much, Karen.
Yes.
Thanks,
We'll
Karen.
flag it, right?
Yeah. All right.
Jack brought up an interesting possible situation. I heard some stakeholders say that the affidavit process would add a unreasonable delay to the process. I also heard Jack McCullough's testimony about needing to have the information about somebody witnessing something is there something in between? You mentioned under perjury and it's not an affidavit, but where if someone was claiming that they saw behavior and it was frivolous or it was incorrect or it was meant to, it was harmful that that person did that they could be held accountable for that action. Defamation, yeah.
What I was wondering.
Yeah. Is there something in between? And maybe that's a Katie question.
So we can ask Katie of that. I will say Brandy Littlefield also sent in the mental health warrant procedure summary. So everyone should read that before we come back for testimony of what they must do in order to go through that process. I'm just real briefly, not to go into depth on here, but questions included on the document to complete the mental health warrant. So it's a legal documentation, personal information, location of assessment, familiarity with proposed patient and other relevant information, mental status examination, threatening or dangerous behavior, eyewitnesses, provide names and contacts information for anyone else who saw the threatening or dangerous behavior, So there's a whole bunch of stuff here. So I think everyone can read that. We'll have Katie walk us through it as well, the process as she knows it, and that can add to our conversation. Does that help, Maureen?
Yes, thank you.
Lori? So, not to beat a dead horse, but I just want to make sure I get it. So right now, today, a mental health professional or a law enforcement person must observe the behavior.
That is not what's happening in practice.
In practice, they're getting word from other folks.
Yes.
Okay, but not with an affidavit or
No.
anything signed.
No, they're going through this form that they get trained on, that they have to fill out, that goes then to get the warrant. But no, there's no affidavit.
They just,
Required.
they can go, they can talk to witnesses, they can, but the statute says that they must observe it. Is that what the statute says?
It says when personal observation of the conduct of a person constitute reasonable grounds.
I just worry this allowing the affidavit could really give people with vendetta a chance to, I don't know, it makes me uncomfortable when I think about it.
So I think we've heard testimony all ways, right? So that's why it's going to be a policy. So some are concerned that it's going to really lengthen the process that's needed to get someone help. And then obviously we've heard Jack's side, right? Like if someone's going to be taken in for involuntary potential treatment, at least to be screened, should they be the ones observing it, who's taking them in? So we're not going to answer that today, but that is something that's out there for us. Leslie?
I'm wondering, when I really appreciated Karen saying that a person in need of treatment is a statutory definition, and it's sort of not sort of flagged that way on line 14 and page 1, and wondering if it's appropriate to ask Katie in the statute to say as defined in, so that we could then reference it as needed in this statute.
Well, I think I have it flagged for Katie to talk to us about what the definition is, but I will leave it up to her to provide legal guidance on if it needs to be changed. As it,
Yeah, I'm not suggesting changing the definition at all. I'm just suggesting.
changing the language, like to your point. Well, let's have that conversation with Katie.
Yeah, just having the reference. I was just wanting to flag that because that's really helpful to me. Thank you, Karen.
Yep.
As we talked about the signed affidavit, I feel like, there's lots of some benefits and also some things that may be a detractor. But one thing that I did see in Brandy's testimony that I think might be something we want to if we decide that an affidavit needs to be signed, maybe having a clause for if it's someone suffering from domestic violence or intimate partner violence, there may be some exceptions that are just cursory, like this is a time when you can just opt out. So it might be something that we look at as saying, all other ways, if you're going to make a statement about someone that needs to get them on a warrant, stand by what you're saying and be able to sign it, but there may be specific times when it doesn't make sense for someone's safety. And that wasn't her testimony.
Okay. Any other thoughts right now? And then the other request that we had, and this is the language that is in front of you with Katie's highlights in green, which again, I'm not gonna let her go through the language. This is what Morning Fox, maybe someone else had brought up about taking someone into custody, but then when is the warrant process initiated? So that it gets down more into the process of when they have to get the warrant in what stage of the process. So that's what's highlighted in green. That came from Morning Fox. And I'm gonna have Katie walk through this with us. So.
Did you flag whether we were going to try to get a definition for?
Yes, I have that under the list of questions. Thank you. All right, anything else? I'm glad we had this conversation because got all the confusion out on the table and back to what we were talking about. Since we had a little bit of break.
And then have a few days to forget it all.
Right, no, we're coming. I'm pretty sure Katie's here tomorrow on this. So we're gonna keep on plugging away on this. So read Brandy's testimony, hopefully before tomorrow. And like I said, we'll have, pretty sure it's tomorrow that we have Katie. Just double check. Yes, Claire's saying yes. So we will come back to this, I promise, quickly. And then hopefully by tomorrow we'll have, judiciary may have some language changes that we could review as well. We would choose to accept them or not. Sorry, I'm just making my final note. Okay, so then the next one is S65. Thank you, Jack and Dylan and Karen. I'm super thankful that you were all here. Help us through that.
Thank you.
Hope to be here tomorrow.
Okay, great. Thank you. You can always zoom in. Yeah. Okay, so S65. Do you mind if I just let you talk about it?
No,
Well, S65 is that.
do we want to do it at 2:30?
Oh, no, we need Katie, right? All right, let's take a 10-minute break. Yeah, let's take a 10-minute break. Perfect. You can tell I want to get out of here. We can go off live. Claire, we can go off live.
But you know what? 10-minute break is not a 20-minute break.
Right.